Okay, let's summarize a wild 2025 South African case about employment contracts after you're fired.
So, does getting fired actually void your non-compete? It's a huge question for literally everyone. Here's the timeline. Hired in January, fired for misconduct by October. Cue the urgent lawsuit. The catch? He signed a super strict 12-month restraint of trade with his old employer.
But he completely ignored it, aggressively recruiting his former colleagues for a competitor called Optic Media.
He didn't just poach clients either. He literally threatened to sabotage equipment and cripple their operations. The company sued, obviously. This sparked a massive legal battle with two totally different court rulings. At first, the lower labor court totally shocked the employer and just dismissed their urgent application.
Why? The judge said enforcing it would unfairly deprive the fired employee of his livelihood.
Well, refusing to back down, the employer appealed, arguing the lower court completely misunderstood the law.
And the appeals court agreed. They ruled that the restraint definitely survives dismissal for any reason.
The one exception, if the employer acted in bad faith, which definitely didn't happen here. Since he was fired after a totally valid disciplinary process, his unfair dismissal claims meant nothing. The court also clearly defined what's legally protectable, stuff like goodwill, staff, clients, and equipment. So, siphoning clients and poaching colleagues were ruled as direct breaches of his contract. Simple. Crucially, the court confirmed they absolutely have jurisdiction over those wild threats of equipment sabotage, too.
They overturned the ruling, completely barring him from soliciting, harassing, or touching any company property.
Which leaves us with this summary thought. Are your employment contracts strong enough to survive court?